state of Colorado is now in session. Chief Justice Bowman presiding.
You may be seated. Thank you. All right. Good afternoon, Council. I don't know if either one of you have argued. We've got those covers. Do you have that and where the procedure? We're finding the hardest part is to take it when you leave. What I'm going to ask that you do after I call the case is to come up to the podium and enter your appearance. You don't need to put the cover on for just that. And the reason is I just want people online to know who counsel are. So with that, the court will call 20SC758, petitioner Nicholas Garcia versus the people of the state of Colorado. Counsel, if you'll enter your appearances, please.
Good afternoon, and may it please the court, Judd Lonis, registration number 33208 on behalf of Nicholas Garcia.
Welcome.
It please the court. My name is Ellen Michaels. I represent the people in this matter. My registration number is 43885.
Welcome, Ms. Michaels. All right, Mr. Lonis, you will have first argument. You may reserve any time you have left over for rebuttal, but you'll need to keep track of your own time, and you can begin when you're ready.
The parameters of a crime are its legislatively defined elements. So when the jury asked the trial court, what are the parameters of kidnapping? The court erred by refusing to direct the jury back to the elemental instruction. The court compounded its error when it instructed the jury that seizing and carrying is defined as any movement, however short in distance. That is not what the word seizes and the word carries mean. The instruction expanded the parameters of second-degree kidnapping to include the type of movement that necessarily occurs in virtually every crime against a person. As a result, the jury did not find Mr. Garcia guilty of second-degree kidnapping as that crime is defined by the legislature, and this court must reverse. I'd like to start today by addressing the preservation question. There are two important things here. First is that the defendants clearly objected to the instruction, the supplement instruction that the court gave. The second is that this court does not require parties to use talismanic language to preserve particular arguments for appeal. Instead, the question this court always asks is, what if the trial court had an adequate opportunity to address the issue that is before this court? It held that in Melendez, Siri, and Salazar. Here, the court ruled, I'm going to give this answer over the objections of the defendants. And then, to quote the transcript, it's simply a statement of the law, and I believe that this statement of the law is correct based on the authorities that I have. Thus, the trial court not only had an opportunity to make a ruling on the issue that's before this court, it actually ruled on the issue that's before this court. That is, whether it's a correct statement of the law to say that seizing and carrying means any movement, however short in distance. So for good reason, the state conceded this argument in the Court of Appeals. And for good reason, this court should not allow them to rescind that concession here today. And if there are no more questions on the preservation issue, I'd like to move on to the merits. The word seizes and carries do not mean any movement, however short in distance. They don't mean that in Webster's Dictionary of the English Language. They don't mean that in Black's Legal Dictionary. They don't mean that in the legal lexicon pertaining to kidnapping statutes and the common law crime of kidnapping. They don't mean that in the legislative history, and they don't mean that in this court's case law. Defining the words that way erases the meaning of seizes. It erases the meaning of carries.
Mr. Lonis, hi, sorry to interrupt. I actually find that definition particularly perplexing given that seize and carry are both verbs and that definition has no verb in it. So I don't see how it could be a definition of seize and carry. Where did it come from?
It's complicated, and I tried to trace that in my opening brief. But essentially, kidnapping has always posed problems for courts, and it's difficult on sufficiency of the evidence review. It's a difficult problem. It's even more difficult trying to define the crime for the jury. And so this court, it's really cases dealing with sufficiency of the evidence or sometimes entitlement to a lesser included offense. We're trying to figure out the meaning of seizes and carries and what is one place and what is another place. And they decided that substantial movement essentially proves the crime. And then, but where there is not substantial movement, the court will consider whether the movement placed the victim at a substantially greater risk of harm. And so that was the case law. And then in Harlan, a case that came out between Netter in the U.S. Supreme Court and Grego in this court, where essentially, if there were erroneous kidnapping instruction, regardless if it was harmless, it would have required reversal potentially. And this court, for whatever reason, didn't want to introduce that doctrine in a capital murder case.
So, Mr. Lawrence, good afternoon.
Yes.
I think we've said in the past that seized and carried means moving from one place to another. And we've also said, it doesn't require that the movement be substantial.
Yes.
And in fact, it can be incidental. That's in our case law. And so the concern I have is, we have case law that seems to imply at least that the movement can be any short distance, yet anytime we've had a case where the distance isn't substantial, we seem to, instead of just saying, well, any short distance will do, so affirmed, the conviction's affirmed. Instead of doing that, we say, well, but because here the movement resulted in a substantial increase in the risk of harm to the victim, then the evidence is sufficient. So, which is it? Where do you think we should land on this? And shouldn't we make consistent what we're telling the jury and what we're using on review?
Exactly. And you should, yes, exactly, because if a substantial risk of harm is relevant to this court's decision of whether the evidence is sufficient, which is just a constitutional backstop to the right to jury trial, then it's relevant for the jury to determine when it's deciding guilt beyond a reasonable doubt in the first instance. And when the court in Harlan, I'm actually leaning on heavily because I think it was mostly correct, that it's not necessarily an element, but it is a factor that a court should use in deciding whether the place-to-place element should be, has been proved, and therefore, if it's relevant for a court, it should be relevant for a jury. And how did we get to any movement, however short distance? Is that somehow after Harlan, the Court of Appeals decided that we're just going to lop off the substantial risk of harm part, and then it was repeated like on a bad Xerox or something. But there's no statutory interpretation going on there. It's just repetition of precedent that's unmoored from the statutory.
So I'll ask you the question that our chief likes to ask. What rule are you asking us to adopt? How would you define it? How should we define seized and carried from one place to another?
Well, first, I would say that when the jury didn't ask what the meaning of that is in this case, but when the jury does ask, telling them that it means any movement, however short in distance, is always the wrong answer. The right answer is going to depend on the jury's question. But as Judge Brown said, the appropriate thing to do is to first make a real determination of what the jury is asking about, and then, if necessary, give a more fulsome definition of the terms. And more fulsome definitions of the terms can be found in Webster's Third International Dictionary, which is this court's go-to dictionary, Black's Law Dictionary. You can look at the common law, And you can also look at the legislative history, which that's what the legislative council report is what the legislature was looking at when it passed the statute containing these words. And it clearly believed that secondary kidnapping was an aggravated form of false imprisonment. And they tell us that kidnapping requires confinement or detention. So that would be a good way to define confinement or detention for starters, or in addition to the dictionary definitions.
Lawrence, can I come at this a slightly different way? Good afternoon to you. Sorry. You said a minute ago you thought Harlan was mostly right. I mean, where was it wrong? Really the same question Justice Samore, I think, may have been asking you. What's the test here? What's the definition? Not how should the judge answer the question that we got here or another, but what's the standard?
The standard is movement must be is the one in Harlan. It needs to be, the movement must be substantial. When it's insubstantial, the movement must be such that the victim is subjected to a substantially greater risk of harm. Now that's the rule. That is the rule of Harlan. But the only mistake Harlan made was its comment that this is relevant for a court to consider when determining whether the evidence is sufficient. Again, if it's relevant for the court and sufficiency of the evidence, by even greater strength of reason, it's relevant to the jury when it's deciding guilt in the first instance.
So, Marty, should we move? Oh, I'm sorry.
No, please go ahead.
Should we move away from this increased risk of harm? It's caused so much confusion. I mean, I get it, right? You move a victim from the roadway to behind a shrub. It was one of the cases. And then sexually assault her, you've increased the risk of harm, but there was movement. It always struck me as a little bit odd that increasing the risk of harm helps you prove that there was movement from one place to another. That those things don't connect to me. So I'm just asking you generally, is that a right approach? I understand why it might be relevant, but I think that's a large part of the confusion that we've had.
Yeah, it's not just confusion, it's difficult because I quoted the Utah Supreme Court wrestling with a similar issue in their case law. And if the court, if any movement were enough, then the legislature would have just stopped at any movement and not had from one place to another. So the court should give one place to another meaning, but the definition of place is quite indefinite, and it is a difficult problem. I think Harlan saying that it must be substantial movement, even though that word itself has ambiguity, or expose the victim to a substantially increased risk of harm, I think that's the best that this court has come up with.
So it's the or, if I could discuss one more question. The or is what troubled me with what you just said. Why isn't the rule just there has to be movement from one place to the other, and risk of harm it can be evidence in support of the movement? Not the, I guess your suggestion was that the court that there should be an instruction to that effect. You have to be substantial movement or a substantial risk of harm. And I'm just wondering whether that's not an instruction issue. It's an evidentiary question. Do you understand what I'm asking?
Yes, I do. And that's why I think generally, as Harlan held, you just give the jury the elemental instruction. And then if the court asks a question that is putting that point at issue, then the court may give an appropriate, legally correct supplemental instruction that's actually supplemental and doesn't erase the meaning of the statutory terms.
Thank you. And I'm sorry, Justice Birkenpower.
Oh, yeah, thank you, Justice Gabriel. So I was, to follow up on what Justice Gabriel and Justice Samore were asking, I just want to make sure I understand where you're drawing the line. Are you asking us to reverse part of Harlan and to make a substantial risk of harm a part of sort of the second part of asportation, make that an element? Is that what you're asking us to do?
No, I'm not. I'm asking this court to, generally speaking, hold that the parameter of the crime is its elements. Now, when a jury asks about the parameters of the crimes, it should refer the jury back to the instructions. If the jury has a question about specific terms, and I will concede that sometimes the jury has asked what the meaning of seized and carried means. They actually, strangely, don't necessarily ask about one place to another very often, which is kind of weird, but why Harlan's explanation of one place to another is essentially always given as an answer to a question about seizes and carries. It doesn't make much sense to me. But I think if a jury is asking about seizes and carries, you tell them, yes, seizes is detention, carries, if it's going to be defined as movement instead of the related term of transport, one of those two would suffice, so long as it's from place to place. But again, my main point is that seizes and carries do not mean any movement, however short in distance. And in this case, that makes a big difference.
I think we're all just grappling with, you have made that point well, and you made other points well. I'm just trying to understand exactly where the line is and what the rule is. Let me pivot to one other question, and then I'll stop asking you questions. Can you think of an example of a factual circumstance where seize is not included, or somehow there is an act where someone is charged with second-degree kidnapping and someone is carried but they weren't seized?
Yeah, especially if carried is defined as movement, as this court did in Harlan. If I were to push someone off a porch, that would be carried without seizure.
Or out of a car?
Or out of a car.
Yeah.
Exactly. I mean, if someone were in an ore car and you pulled the lever, sending them down the mine, I mean, that's just a kind of a far-fetched, but the truth is that life will give us many more examples where someone is carried but not seized. This case presents one of them. I see I've made my point regarding maybe too often regarding the statutory meaning, the meaning of the statutory terms. But you are asking about a rule to apply. And I will conclude by saying that the correct answer to a jury's question always depends on the words of the question. So the court must pay particular attention to that.
I think the problem comes up because you tell the jury seized and carried any person from one place to another as an instruction, and you have lawyers arguing about whether that element of asportation has been met, and so you have jurors who want to know, well, how long does the movement have to be, right? Seized and carried from one place to another. And so you get these questions that the judge got in this case, and or similar questions.
Right.
So what's the answer to that? Because we've said repeatedly, seized and carried means moved from one place to another, or it is satisfied by movement from one place to another. And we've said the movement doesn't have to be substantial. And I don't read Harlan to be saying the opposite. I'm not sure what part you're looking at, but I don't read it as saying the opposite. I read it consistent with some of the other cases. So the only one that's a little that's different is Fuller, which did say that the prosecution had to establish that the victim was moved and that the movement substantially increased the risk of harm to the victim. And then Harlan, I think, did its best to harmonize that case with the rest of our case law. But outside of that, we've been consistent, this court has been consistent in saying the movement doesn't have to be substantial. It can be incidental to other crimes. So.
Yeah. First, I disagree that Harlan held that seize and carry means any movement, however short in distance.
Well, I'm not sure if it was in Harlan specifically. I'm sorry. I'm not sure that it was in Harlan, but I know we've said that in cases that, and it may have been Harlan, but I know we've said that it's movement from one place to another.
Well, actually, the court held that the asportation element is movement from one place to another. Now, asportation is different than the seizure element. And then at one point in Harlan, the court conflated the detention seizure and with the asportation element, and that's whence all this confusion of the Court of Appeals came, when it said the asportation element, or seizes and carry means any movement however short in distance. But at the same time, Harlan twice held that the asportation element is movement from one place to another. So Harlan's holding didn't even consider the seizure element, for example, but at one point during his discussion, it conflated the seizure and asportation elements. And so, and this is why I'm saying that the rule would be the parameters of the crime are statutory elements. The jury should generally be instructed in the statutory elements, because if they give seize and carry in one place to another, their common meanings, they will find that kidnapping has been completed or not completed as defined by the legislature. If the jury asks questions about seizes and carries, as often happens, rather than from place to place, the jury should be instructed on the meaning of seizes and carries and their separate meanings. If the jury does ask about the meaning from movement from place to place, then I believe a Harlan instruction is appropriate. The one that the Harlan said a court should consider when determining whether evidence is sufficient, I think that would be the jury should also get that instruction to decide whether the evidence proves the crime beyond a reasonable doubt.
So our conversation this afternoon makes me think that we do better to admonish trial courts simply to refer them back full stop, right? Because even if there are questions about these details, there's so many different permutations here that it seems like we run the risk of creating more problems than we're solving. And so why wouldn't it be better just to, I realize Leonardo and other cases suggest that when they ask a specific question, we should generally strive to answer it. But I kind of like where you started, just refer them back. And then we don't get into all these sufficiency cases that really aren't supposed to be the basis for instructing juries in the first place.
That is a good point. I actually, in preparation for this argument, I read an article that you penned as a district attorney, and one of the things you stress is there are dangers to giving supplemental instructions, but also dangers to not giving them.
Oh,
And it's
I remember
you may
this
not
one.
remember that.
He was young and impressionable.
And
I do remember now.
certainly the easiest, the clearest solution is to refer the jury back to the elements, especially when they're asking about the parameters. Parameters are the boundaries. No supplemental instruction should expand the boundaries so that it gathers in a bunch of conduct that does not fall within the definition of the crime. And so certainly in this case, it's a question about parameters, you direct the jury back. I think if the jury asked a question about a specific terms, if the jury had asked about seized and carried, for example, the court could define seizes as defined in Webster's, carries as defined in Webster's if it really needed the help. It could not conflate the terms and then say that it means any movement, however short in distance. So again, I think if a jury is really struggling with the meaning of a particular word, I think the court should have discretion to tell the jury what that means if there is an answer available beyond identified in the case law and in the statute. But the court has to be careful when it does so, because the court has discretion to give an instruction that accurately states the law. And if it doesn't accurately state the law, that's just error.
Can I follow up on, oh, I'm sorry, go ahead.
Well, just kind of following up on that, if that's all right. So to the questions asked here, what are the parameters of kidnapping? You just say, go back to the jury instructions, right?
Yes.
Okay. Is it considered kidnapping if a person is put in the back of a car? Is it kidnapping if they are dumped and left behind? How would you answer those questions?
I would answer them no. I mean, I don't
Okay,
think
not
the
as a
jury-
defense attorney. Okay. I mean, as a judge, how would you answer that question?
I think, yeah, well, that is the question in this case, and I would have directed the jury back to the elemental instructions. Since
I mean,
they're-
wouldn't you, I mean, because wouldn't you agree that it could be considered kidnapping if a person's put in the back of a car?
assuming the other elements are proven, and
Right, right.
and the person's seized and carried, and that's one place to another.
Right.
The problem is, to me, that this question asks more about place to place, and the court's answer doesn't answer that question, and not only erases, seizes, and carries, but diminishes the place to place requirement.
Okay.
And so I think a court in this case would have discretion to give the Harlan substantial movement or substantial risk of harm test as a jury instruction.
So could the judge here have answered it?
Sorry.
Go ahead. How would
court-
you have answered that, putting meat on the bone here?
The court would have said, a person has moved from place to place if he has moved a substantial distance or the risk of harm.
Or the movement increase the risk of
Yes, or
harm?
the movement substantially increased the risk of harm to the victim.
Well, let me pick up on that's where I would go in the same place the chief was. I mean, these latter questions were evidentiary in nature, right? They're asking about, what do you think of the evidence here? I mean, I don't think the trial court ever answers those questions.
Well, yes. I
And
agree.
then following up on that, so you've said now a couple of times that if the jury said, you know, what do you mean by place to place, you should instruct on this point, this concept of if it increased the risk of harm. And I guess I'll push back a little. Why? I mean, that feels like an evidentiary point too. The best answer might be, you know, you're to use your judgment based on all the evidence you heard on whether he was moving from place to place. The end. I guess I'm not sure why we'd ever tell the court to instruct the jury about this substantial increased risk of harm here, if it's an evidentiary point and not an elemental one.
Right, let the parties argue that. I do think, though, if the parties argue that he's not moved from place to place because there was a substantial increased risk of harm or it's insubstantial movement, I think the jury might come back with questions. But I would caution this court not to try to resolve every kidnapping case that will ever come out in the future in the state of Colorado today. I'd ask it to resolve this case. And as you said, the latter two questions were factual, and the court should not have tried to answer them. It should have said, I can't answer your factual questions. It should have not have tried to infer what particular parameters the jury was thinking about when it gave forth those factual scenarios. And it completely erred by giving an incorrect statement of the law as an answer. If there are no further questions, I'd like to save my remaining time for rebuttal.
You may. Thank you.
Thank you.
Ms. Michaels? Oh, Mr. Lonis, if you'll grab your. Everybody does, yeah.
The jury instructions, as read as a whole in this case, instructed the jury that the prosecution had to prove beyond a reasonable doubt that the defendant seized and carried the victim from one place to another without the victim's consent and without lawful justification, and that seized and carries means any movement, however short in distance. This is a legally correct statement of the law, and the court's decision in this case to give a supplemental instruction derived from case law and taken from the model jury instructions was not an abuse of discretion.
So I'll jump right in. Good afternoon to you, Ms. Michaels. So why doesn't seized and carried means any movement, no matter how small, inconsistent with from place to place? Because presumably you can move someone 3 inches, that's however small, and that's not from place to place other than the most theoretical idea.
Correct. And I think it's important to recognize that in this case, the court limited its supplemental instruction to the seized and carried piece. So you have to read them all together. And so the jury was told that is any movement, however short in distance, from one place to another without lawful justification. And so I read the seized and carried as a broad standard, and then the from one place to another as a modification of that. So put another way, it's any movement, however short, but it has to be from one place to another. Does that answer your question?
Yes.
And so, Ms. Michaels, if that's the case, if insubstantial movement will suffice, and we've said that the movement doesn't have to be substantial and it can be incidental, then why is it that when we've had cases where the movement is not particularly clear or where it's insubstantial, we haven't just said that. We haven't said, hey, it doesn't matter because it doesn't have to be substantial. What we've said is, well, but in this case, it substantially increased the risk of harm to the victim, therefore the evidence is sufficient. Wouldn't it have been easier to just say, it doesn't matter, any distance will do? I mean, it seems to me that implies that we don't think that just any distance whatsoever will do. Otherwise, we would have said that, right?
Well, then, but it still has to be from one place to another.
Right. And so, but what I'm saying is when it seems like the movement is insubstantial in the past, we haven't just come out and said it doesn't matter that it's insubstantial. The evidence is sufficient for second-degree kidnapping. That's the end of the analysis. Instead, we've gone with this increase of harm to the victim. And if that's the case, if we think that that's something that has to be proven when the movement is insubstantial, then shouldn't we be telling the jury that? Should we be waiting until review to apply that standard?
So I don't think that the substantial risk of harm is, as we know from Harlan, it's not a required piece of the statutory element, but it's a factual consideration that can come into play in sufficiency of the evidence standards. Now, that being said, I think the jury instructions as they are today give some room for that to be an additional instruction to the jury in an appropriate case. So I don't think that it would be inappropriate to refer to the jury to that standard in the correct case. But I would say in this case, the defendant did not ask for that instruction.
What would the right case be? What would that case look like?
I honestly don't know, but I think that's why we
And
give...
I'm sorry to spring that on you.
And I think that's why we give, we look at the instructions as a whole to see if they accurately reflect the law, but whether to give a particular instruction or a supplemental instruction is really left to the discretion of the trial court. And I think it's because there are so many factual permutations that can occur that we want to give the court, who's there in the moment and can see how the evidence played out and how the credibility of the witnesses came across, we want to give that court the opportunity to give the best instructions possible in the case.
Ms. Michaels, I'm going to sort of ask the same question I asked Mr. Lunas. I didn't practice criminal law, and I'm just being a grammar nerd, but I don't understand how a definition of two verbs, seize and carry, can be any movement, no matter how small. And if I were on the jury, I would have been super confused by that statement. Isn't any movement, no matter how small, more applicable to from one place to another? That's describing it can be a small movement from one place to another. And then didn't we say in Harlan, in that instance, there's going to have to be something else that shows it's from one place to another, which might be an increase in the risk of harm. If you move someone from in front of the apartment building to behind the apartment building, you could argue that's not really from one place to the other. You're still at the apartment building, but you've really changed the dynamics. Or from the road to behind a bush, not very far, but you've really changed the dynamics. So it's from one place to another, or it could be substantial movement, in which case there doesn't need to be harm because we know that's from one place to another.
So as to your first piece, I think it is linguistically, honestly, it is linguistically a little confusing, or it doesn't sound exactly right, but as we know that awkward language doesn't mean that something is wrong. And this is developed in a very legalistic area right? I think when we're instructing the jury about these things, we want to make sure that the jury understands that second-degree kidnapping is not actually first-degree kidnapping, which is, I think, what a lot of jurors think about when they think about kidnapping, is the more traditional first-degree kidnapping where you take the victim and you keep them away for days on end. And that's not what second-degree kidnapping is, or what the purpose behind it is. It is any movement against the victim's will, however short in distance, is kidnapping.
But I guess, let me come back to something you just said, called this to mind. You're right, jurors are not lawyers, for the most part. We're not excluded, but you don't see a lot of lawyers on there. In this case, the question was, what are the parameters? And then they gave these couple of examples together. And the court, as if dump them out of a car, or whatever else they said. That was one question. And the court goes back with an answer that says, seizes and carries as any movement, however small. Why wouldn't the jury, just a rational person, have understood that's the definition of kidnapping? That's what they were asking. And that's my concern here. You said, and it's a good lawyer argument, seizes and carries meant one thing, but didn't exclude the one place to another. But the question was about the parameters. And why wouldn't the jury have taken it that way, particularly given Justice Hart's, really good point that the definition the court gave seemed more closely aligned with place to place. So put yourself in the place of a juror, and how is a juror going to understand that?
Well, the jury gets the full set of instructions, and
That's a lawyer argument, and I don't mean that disparagingly. I understand it. I'd make the same argument if I were standing where you are right now. But again, when you get asked about seizes and carries, as Justice Hart points out, and you get a definition that's really about movement, why doesn't a juror say, well, this is the definition of kidnapping now? Or at least cause serious concern as to whether that was the case, particularly given the defendant's theory of the case was the hypothetical the jury posed. Is it enough if they just dumped him out of the car? That was the defendant's theory.
So, again, we read these together, and I think in this case, we have the way that the instruction was worded didn't say kidnapping is defined this way. It says your question goes to the seize and carry piece. This is defined as. And so I think the jury could understand that we're talking about one piece of it. We're not talking about the entire kidnapping instruction and all the elemental pieces of that.
But doesn't that go to Mr. Lonis's point that the judge arguably answered a question different than what the jury asked? They said, what are the parameters of kidnapping? They didn't say what does seized and carries mean.
I think when you look at the hypotheticals that came afterwards, I think it's a reasonable interpretation from the court that what they're really talking about is seized and carried. And as we know, the court couldn't have answered these factual questions. And the prosecution's closing argument brought this up. They said, even if you believe the defendant's son's testimony, that's still kidnapping, a short distance. And so I think it was a question that was presented in the case, and the jury was confused about, and I think there needed to be some more explanation of this. So there seem to be about two major veins to the argument that I'm hearing today, one being that the amount of movement should be more significant, and the other one being that seize kind of reads, any movement, however short, reads the word seized out of the statute. And as to the first piece, putting aside for a minute what it means to seize, the language the trial court used in the case, the any movement, however short in distance, has a strong basis in law going back at least 35 years to the Apodaca case, and I think even further to the Yesca case. And I think it is an accurate statement of what it means to carry. So to the extent the defendant is asking that this court move away from the rule that the movement need not be substantial, there's no real principled reason to do so in this case.
Could you answer then Mr. Lonis's hypothetical? If I push someone out of a car, is that seized and carried for purposes of kidnapping? That's the only facts. I pushed him out of a car.
Well, it's not from one place to another.
But it's seized and carried, right? Where's the seizure in that hypothetical?
Well, if he's in
pushed out of a car.
Well, if he's in the car, I think.
He may be in the car voluntarily, and I pushed him out of the car. That's the problem.
Well, it's any movement, however short in distance.
I pushed my friend Justice Samore out of the car when we're driving. He's there voluntarily. I have moved him any distance.
I am not riding with him, ever.
I mean, the problem with hypotheticals is that there are so many different factual ways that these come out. I can say in this case.
No, but it's not hypothetical, and I'm sorry to push, but I'm just pushing on you, obviously, for purposes of argument here. It's not hypothetical because the defendant's position, which I know the prosecution and the AG here strongly disagrees with, was that's what happened. He's in the car voluntarily and they dumped him in an alley. That's their position, which I know you disagree with. But if the jury were to believe those facts, that's second-degree kidnapping based on the definition the court gave. We have a seizure and a carrying.
So that's not what the defendant's theory of the case was. He didn't give a theory of the case instruction, but his oldest son testified that this was a meth deal gone bad, and so they get to the first alley, the defendant gets the meth, and then he brings it back, and the victim, who is in the middle of the back seat, says, "No, you shorted me," and then the defendant's son starts driving several blocks while there's a fight happening in the back of the car, and then they come to another alley. They don't just push him out, they pull him out of the middle seat, and then they assault him. So that isn't the same as pushing someone out of the car.
Although the jury seemed to think otherwise. Their question was based precisely on the hypothetical I gave you.
Well, I
Is it
think
enough
that-
if we dump him in an alley? That's
and
what they asked.
And I think that depends on what you mean by dump in an alley. If you mean I pulled him out of a car and assaulted him, which is exactly what the brothers testified to consistently, I think that probably is kidnapping.
So if you look at page 311 of the transcript, on September 26, 2017, I call him the son, Mr. Garcia, the son that testified, is talking about the scuffle in the back seat. He says, I reached back and I tried to get Troy off. Then the car stopped and we managed to get Troy out of the car. And that's when I assaulted Troy. So that's different ever so slightly still.
But then I believe this is the same son, testified the next day. This is page 323, that the co-defendant pulled him out of the car, and he did as well. And so I think that's a little different, that he was pulled out of the car.
Right, so you have two different statements, and the jury can decide what, to believe some or all or none of the testimony of the witnesses.
Well, I think that was more of like a dug-down version. At the first day of testimony, the guy testified, the son, testified at the end, and it was a little bit just kind of like broad view. And then it was the next day that the lawyers dug down with him on it.
So I'm sorry to
But
keep...
by any version of the facts, the defendant or the victim was in the middle seat of the back, and then was brought out and assaulted. And the pictures supported this. He had significant injuries to his elbows and his knees, indicating that he was in fact dragged out.
So I wasn't trying to get us into the facts. I was trying to get a legal question, and although I do appreciate your argument on the record here. Let's take a hypothetical. The only facts here are they pushed the guy out of the car. You would agree, would you not, that under the court's definition here, we have seizes and carries? Because we have any movement, however small.
I think potentially, yes.
All right, so how does that not read the word seizes out of the definition of kidnapping?
Well, I think seizes, to the extent that there is a case, I think seize is usually subsumed, if not always subsumed, in the word carried, because it's important to recognize that in kidnapping, there is no force that's really necessary for the taking. And a seizure has been synonymous with taking. So anyway, I think the force there's no force, and I'm sorry, can you repeat?
Yeah, no, you're fine.
I kind of got lost.
And I'm sorry to take so much of your time. Obviously, we have to write a rule for all cases, and I understand Mr. Lonis's argument. We just decide this one. But my concern is this definition of seizes and carries, because the hypothetical I gave you at least is a case where that definition doesn't work. It does read seize out, and that's what I was trying to get to.
Yeah. And I think I actually agree with Mr. Lonis that we can decide it on this case, because if that case ever occurs, I think that would be the case. But instead of trying to adopt some additional rule here that isn't really implicated by this case and may or may not be a perfect fit, I think we save that for the case where that is actually the issue that arises.
Thanks, Ms. Michaels.
And then I do want to,
So, Ms. Michaels, I'm sorry. So you mentioned Apodaca and I think even Yescas. Did we actually say in either of those cases, any movement, however short in distance? Have we ever said those words in relation to the second-degree kidnapping?
I think it was definitely said in Harlan, is my recollection.
Any movement, however short in distance?
I believe so.
I don't remember our court. I think the Court of Appeals has said it multiple times. I think what we've said is that it doesn't have to be substantial and
Yeah.
that it can be incidental.
Okay.
But I don't think we've ever said any movement, however short in distance. Do you view what we've said to mean any movement, however short in distance?
I do. And I think because the kidnapping statute is meant to be broad in its reach, the movement of a person against their will should be enough to establish second-degree kidnapping. Turning to the preservation issue, another problem with this case is that the claim is unpreserved, and so it's not very well squared up for this court. And I think this is subject to plain error, and what we know here is that this instruction that was given is taken from the model jury instructions and from significant case law. And so under that, it's hard to know how the court should have known that this was incorrect.
Although you conceded that argument on the Court of Appeals, didn't you?
Correct.
And what did we say about that in Struckmeyer?
I understood Struckmeyer to be an issue on waiver, where my office was making a new waiver argument, a newfangled legal argument for the first time on appeal. And I understood that not as overturning the significant case law that you all have developed that says the court should review on the legal basis that is correct as opposed to on what was conceded. I just understood that as being this court giving short shrift to our argument.
Do you see some irony in your arguing that the defendant didn't preserve an issue that you conceded below, when you conceded preservation below? I'm troubled. I'm not going to pick on you here, Ms. Michaels. I'm troubled. I mean, in Struckmeyer and Rigsby, I think we said pretty clearly it's not proper for any party to concede something below and then change their mind in front of us, particularly, I would say, for the people, where your duty is to do justice. And so, I mean, I, with all due respect, I don't think it was so limited. But so help me with why it's appropriate for you to concede it was preserved below and then do a 180-degree turn in front of us.
Sure. It wasn't first of all, I would point out that there's a talent case that came out, I think, 2 months ago from this court applying the same review to standards of review, even though the parties had conceded otherwise. And certainly, I think this court could come out with a clear ruling as to what it means in these situations. But ultimately, this court's job is to apply the correct law. And this isn't a waiver situation where my office understood the legal implication of something and for whatever strategic reason didn't go with it. It was a mistake, and I don't know that it is something that should be binding all the way up to the Supreme Court. And I would also point out that I think there is a little bit different standard for waiver in the Court of Appeals and in the trial court. The reason we have a waiver doctrine is that we don't want a party in the trial court to say, oh, no, I'm not going to raise that. And so then it affects the quality of the record on that issue, right? A party will not present evidence and so on and so forth. And then we don't want that party to come up to the Court of Appeals and say, they presented no evidence. And so that's why we have the waiver argument, right? We're stuck with the strategic decisions that we've made. Here, we don't have a strategic decision that was made. And I think it also is a little bit different in the court, because again, in the Court of Appeals, because again, the court has an independent duty to apply the correct law, and this doesn't affect the record in the case or anything of that nature.
Did you cite Struckmeyer in your brief? I mean, I read it the same way Justice Gabriel does, and I think we were pretty clear about disapproving of the Attorney General's office raising a preservation argument in front of us when they had conceded it at the Court of Appeals. Did your brief cite to Struckmeyer?
It did not. I did not read it that way. I was not aware that it was being read that way. I understood it as being an issue of of waiver. You don't get to raise waiver for the first time. And I know that waiver is often something that we group together in standards of review, but really it's almost a procedural bar as opposed to a standard of review.
Just as a practical matter, it seems to me that when we grant cert on an issue, we probably didn't grant it thinking that the issue wasn't preserved. And yet it always, and I don't mean to pick on you either, but the AG's office always seems to leave with lack of preservation even before us. And so irrespective of the debate that you're having now, I don't know, it just seems like sometimes it's, insulting is probably too strong a word. Just, if we've granted cert on it, we probably think that it's in play, right? So just thinking out loud. I don't really have a question.
And certainly if this court wants to reach the merits of the case, I think that's fine, and that's why I've led with the merits. I think the problem becomes that it's just not very well squared up because it wasn't preserved. And I think that's something that probably does need to be at least recognized in the opinion so that when other courts come to look at this opinion for guidance, they can understand kind of why that is, that there might not be as much to it as we would like.
Can I take you back to the merits? Let me ask you what I asked your opposing counsel. Putting aside how the court answered these questions here, how would you, as a judge, how would you have answered, what are the parameters of kidnapping? Is it considered kidnapping if a person is put back in a car? Is it kidnapping if they are dumped and left behind? Ideally, how would those questions be answered?
And I think the court, I think the court did the right thing here because, first of all, I'm not sure that these questions really have to do with the facts of this case. I think they are hypotheticals. What if somebody's put back in a car? Well, I don't know that the facts of this case really implicate that. What if they're dumped and left behind? Again, that's not exactly what happened here. And so I think reading this as a hypothetical about, and especially in combination with the rebuttal closing of the prosecution saying, even if you believe the defendant in this case or the testimony presented on his behalf, it's still kidnapping. So that is what's before the jury, and I think it's fair to read this as a question about what sees and carries means.
Okay, so regardless of if you've had all this time to think about it, the trial court gave the perfect answer here. I'm just saying, in a perfect world, how would those questions be answered?
Well, and we can't give we can't give yes or no answers on factual questions, right?
Right.
And we've also instructed the jury, or we've also instructed the trial courts to try to answer these questions in Leonardo. So it does put the court in a kind of a tough place. We have to answer it. It seems to be a question about a legal standard, and there is this model jury instruction saying that you can give this as an instruction in your discretion. And so I think the court did the best it could with a strangely worded jury question.
Okay, so okay, that's fine. You've answered my question. Thank you.
One of the points that Judge Brown made in her dissent was that it was problematic for the judge to separate seize and carry from one place to another. You disagree with that? You think you can think about those two things as separate things?
I think it has been thought of as separate things in the case law. It's been any movement, however short in distance, and then the substantial increase of harm, I think, tends to go to the from one place to another element. And the court followed the model jury instruction and there was never any objections to that on those grounds.
So following up on the Chief's question, in an ideal world, would you have said instead, seized and carried a person from one place to another means any movement of that person, however short in distance, from one place to another?
I think that probably would have been a little bit clearer. Well, or to say seized and carried from one place to another means any movement, however short in distance, from one place to another, I think would probably be a more fulsome instruction. Again, I think, those pieces are scattered through the jury instructions, but to have it all in one place, I think probably would have been ideal.
What do you think from one place to another means? What does that mean to you? Does that mean, from one room to another? Does it mean, can it be within the same room but a certain distance? Does it have to be from one building to another? What does that mean from one place to another?
So the 1964 report that the defendant cited discussed room to room being covered in this. And I think it is really a factual question, of course, but I do think it has to be from one place to another. I don't think it's just any movement, however short in distance. Otherwise, we would be reading out this whole portion of the statute.
So, Ms. Michaels, I guess I have the same question for you that I asked Mr. Lones. And I, after listening to all this and having read it, I don't know that we're really improving on just the elements. I mean, he said, well, at the very least, you should probably, the court should have the discretion to give dictionary definitions, but I don't know that those synonyms ultimately improve on just the language of the elements of the statute. So why not? I know that Leonardo and other cases suggest that particularly when a legal question is put to us or put to the trial courts, they should try to answer it. But it seems like in some instances, maybe we do better just to refer them back. Why isn't this such a situation?
I think that between the prosecutor's statements in closing and the way the jury instruction was worded, I think the court in its discretion could read this as a question of law. And this court has said you need to try to answer those. And so if this court feels that that's no longer the appropriate standard, then we need to tell the trial courts that, because otherwise they will continue to try to answer these questions as they've been informed that they need to do. But otherwise, we give the court a lot of discretion in how to deal with supplemental instructions, because we have, on the one hand, told them you need to try to answer these, and on the other hand, we know that the court is in the best place to decide, how do we consider this and how do we instruct on this.
Maybe we could cure the inconsistency here by being inconsistent on the other front. What do you know?
And I also wanted to point out, going back to the question about if did the jury believe the defendant's version of events? And I think probably not, because the defendant was convicted across the board of everything. And so, and the injuries to the victim were substantial in this case, and it just didn't quite mesh with how the defendant and his co-defendants described what had happened at that time. And then also, quickly, going back to the question about preservation, I know this court seems displeased that I pointed out that this is a different standard of.
And I feel like we've beaten up on you too much about that today, so I apologize that you're taking the hits on that.
But I think you have to understand that this would apply to defendants also. And I have had cases where a defendant says this should be reviewed for abuse of discretion, but it's actually a legal question. It should be reviewed de novo. My job is to tell in my standard of review that this is de novo review. Now, if we say, oh, once you've said it, it is, no longer. You have conceded it, my answer is going to be different in my brief, and this court is going to be, required to hold the defendant to that standard. Same thing with, standard of reversal. Let's say it's structural error, and a defendant says it's harmless beyond a reasonable doubt. Should they be held to that concession? Probably not. We should apply the correct standard of law, because that's what courts are supposed to do, and also because not doing so really confuses the law. And I see that I'm out of time.
All right,
There are no
thank you,
further
counsel.
questions. Thank you.
Got a little bit over 3 minutes.
Your Honors, I'd like to get back to the question the jury asked in this case, and that is, it's on page 236 of the court file. They ask, what are the parameters of kidnapping? Is it considered kidnapping if a person is put back in a car? Is it kidnapping if they're dumped and left behind? Now, I believe that the jury asked those questions because they believe that might be a factual scenario in this case. So I disagree with the Attorney General's argument that that's just a random hypothetical they came up with. You know, it's not, what are the parameters of kidnapping? I don't know. Who won the World Series in 1969? You know, it's focused on this case. I also remember the facts of the case being different, and actually, there's no testimony in which Nicholas Garcia pulled the victim out of the car. The Garcia brothers' testimony was that the victim was beating up on Nicholas, and Llano Cintron, the co-defendant, pulled the victim off of Nicholas. And Jero Garcia testified that he might have helped Llano Cintron pull Kane, or the victim, off of Nicholas. So I don't see how Mr. Garcia is guilty because under the defense testimony that someone is beating him up because he's upset about a drug deal, and his friend pulls the victim off of him. I mean, that is just not a third party who intervenes in a fight on either side does not ipso facto commit kidnapping.
Mr. Lawrence, let me ask you, picking up on something Ms. Michael said, if the court had said instead of what the answer gave it, if it had said, seized and carried from one place to another means any movement, however slight or however short in distance from one place to another, would that have been okay?
No, because however short distance has no place in it. That diminishes the place-to-place requirement. Jury should never be instructed.
No, it would have included the from place to place. It would have said seized and carried from one place to another means any movement, however short in distance, from one place to another.
So I'm in a place and now I'm in another place and I moved any distance, however short. I don't think if anyone did that to me at gunpoint, that would necessarily be kidnapping. A store clerk who's robbed may be kidnapped if they're taken out to the back alley, but they're not kidnapped if they step 2 feet to the right to open the till. And that's one big concern with courts, commentators, and legislators, is that kidnapping needs to be defined in such a way that any other crime against a person is not, by that very fact, kidnapping.
So how are we conveying that to the jury now? Let's assume that what you just said is right.
By telling them that the victim must be seized, an active verb, not a gerund, must be carried, and that has to be from one place to another. And that's a really good way to do it, just the way the legislature said.
All right, thank you, counsel.
I thank you for your time today.
I thank both counsel for their arguments. Case will stand submitted, and we will be in recess until 2:15.
Board is in recess until 2:15.
Before I call the case, a couple things. One is, I already see the covers up there. After I call the case, I'm going to ask both counsel to come to the podium and to enter your appearance so that people online can tell who the attorneys are. And you're familiar with the cover there. All right, court will call 20SC583, People of the State of Colorado versus Patrick Rao. Counsel, if you're enter your appearances, please.
Your Honor, Doyle Baker, Deputy District Attorney from the 4th Judicial District in Colorado Springs for the people.
All right, welcome, Mr. Baker. Counsel?
Good afternoon, Chief Justice. Tim Bussey, 23730, representing Mr. Rao.
All right, welcome, Mr. Bussey. All right, Mr. Baker, you have 30 minutes for your argument. You may reserve any time that's left over for rebuttal, but you'll need to keep track of your own time, and you can begin when you're ready.
Thank you. The Court of Appeals in this case has departed from nearly 30 years of case law regarding the question of whether the common areas in an apartment building are part of a dwelling under the Make My Day statute. In 1992, in People v. Cushenberry, a different panel of the Court of Appeals answered that question no, holding that the common areas of an apartment building are not part of the dwelling under Make My Day. Cushenberry has stood the test of time. It's not been overruled. It hasn't been abrogated by legislative action. Nevertheless, the Court of Appeals in this case departed from Cushenberry and refused to follow it, thereby calling into doubt what had been a uniform understanding of the dwelling question in the context of the Make My Day statute.
Mr. Baker, had that, and good afternoon over here. It's hard with these, I know. Good afternoon to you. Had Cushenberry ever been, had this issue come up since 1992, either in the Court of Appeals or here? And I guess the reason I ask, I think you would agree, Cushenberry has no analysis at all. It makes the statement, it cites a couple of cases. It's a 1.5-page opinion. So has this come up in this interim?
Not that I'm aware of, not in a published opinion. I guess I'd point out a couple things about Cushenberry. I agree the analysis is sparse. However, Cushenberry does give us some clues about where the court was going. They don't tell us much about the apartment that was at issue in Cushenberry, the building, compared to the building in this case. But they do say that the common area in that building was used by other tenants and their guests, indicating that this is an area that has some restrictions on use, but it's still a common area. But it's limited not to members of the general public, but to people who are tenants or the guests of tenants. And they also, in Cushenberry, when they state their conclusion that for purposes of the Make My Day statute, the common areas of an apartment building do not constitute a dwelling, they cite to the first-degree and second-degree criminal trespass statutes, which draw that distinction between a dwelling and a common area. So you're right, Cushenberry is about the shortest case that you can find in the Pacific Reporter, I think, but it does give some guidance there. And the interesting thing about Cushenberry is that in the almost 30 years since it was passed, the legislature's reaction has been to leave it alone. And we have a situation with another case involving interpretation of dwelling where the legislature jumped on that question immediately. And that, of course, was in 2016 when a couple of district court divisions looked at this in the context of prison cells and decided that the Make My Day statute and the definition of dwelling extended to that context as well. And then the Court of Appeals, in an appeal that followed from that, reached the same decision. And the legislature quickly responded to that.
Mr. Baker, you mentioned that the Court of Appeals in Cushenberry cited the trespass statutes.
Yes,
Do
ma'am.
you think that, obviously completely different factual circumstances, do you think that the person who Mr. Rao shot could have been found, could have been convicted for trespass if instead a police officer had come and removed him?
I think he could have, probably second-degree criminal trespass. I suppose there'd be a question about whether we would charge that as trespass of a dwelling, but I think that the statutes themselves answer that because they distinguish between a dwelling, which is first-degree criminal trespass, and then on an alternative, the common areas of an apartment building or a condominium or a motel, there's a list of things, are second-degree criminal trespass. So I think the legislature has looked at this in context and made a conclusion that although we're talking about a dwelling and they have a broad definition of dwelling in the definition section, they're carving out an exception in the context of the common areas of a building like this, an apartment building.
In Cushenberry, the brief opinion mentions that the stairway could be used by tenants and their guests. In this case, do you think the expectation of the 7 apartment owners was that the basement would be used by other tenants' guests, or was this a basement that was reserved for the tenants, given the uses that it was put to for heating and things like that?
I don't know that the record's well developed on that. I just speculating, if you're a tenant or a guest, say you're hosting your child or a parent and you're not there and they're in the apartment and they don't have hot water or they need to turn up the heat, I would think that since they're guests, that access to the building would be the same for them as it would for one of the tenants. But I can't answer that definitively. I'm just not sure.
While you're stopped here, Mr. Baker, if I can ask you just about some of the cases Mr. Bussey cited. There's out-of-jurisdiction cases talk about that they have, you walk in a building, there's a locked door, you're kind of in the landing area about the building. And those cases have said it's part of the dwelling as long as it's behind a locked door, not accessible to the general public. Why wouldn't that be a good rule to adopt here? And I'll put my cards on the table. I'm a little bit concerned about your rule that says common area is never part of the dwelling. And frankly, I'm a little bit concerned about Mr. Bussey's rule that says always a factual question. So looking to give guidance, why doesn't it make some sense what these other cases have said? If it is not accessible to the public, behind a locked door, that's part of the dwelling. I mean, I think we would say it's part of the dwelling if this was a single family residence, this basement.
I agree, there'd be no question.
So help me with that. Why isn't that a better rule?
I think none of the cases Mr. Bussey cites are dealing with the Make My Day statute like this. And Make My Day is unique. It gives uncommonly broad authority to people to use deadly physical force. Before Make My Day, there was nothing like it in Colorado. And that's important, I think. And because of that, you have to look, I think, at the legislator's reaction to Cushenberry in this case. And I don't mean to dodge the question, but I don't think that those cases that don't deal with Colorado's Make My Day statute provide much guidance to the court. And I'll try to explain why. And I'll start with Rao. If Rao is correct in its interpretation, all parts of an apartment building are a dwelling. And that would include areas where a tenant has at most shared control or maybe no control at all and no access or right to enter a certain portion of the building. And if you're in common areas, tenants are often going to be indistinguishable from trespassers. I mean, you think about that. If you've lived in an apartment or you've stayed at a motel, you encounter people in the common areas and you have no idea who they are and what they're doing there and what their purpose is. Under Rao, an apartment dweller has to guess if they have legal authority under Make My Day to use deadly physical force. And I would just use Mr. Rao's circumstances in this case as an example of that. There was no indication from the interview that Mr. Rao did with the detective that he recognized the man who was shot. He assumed the man was an intruder, and he guessed correctly in this case, but he could have been wrong. There were questions that would have been very helpful to know at the moment that he made that decision. Who was this man? Did he know anyone who lived in the building? How did he get in? We don't know these things. And at the time that the shooting occurred, there was maybe not much uncertainty, but there was some uncertainty about who this man was. And just contrast that for a moment with the apartment where Mr. Rao lives on the second floor. If this confrontation had occurred there, Mr. Rao could be confident that the man was an intruder because he was the gatekeeper to that apartment. He controlled access. He could keep out everyone, his landlord, the government, and he knew who had a right to be there and who did not. So those questions, who was this man? If you're in the apartment, you could say, well, I don't know, but it really doesn't matter. Does he know anyone who lives in the apartment? Well, apparently not. I don't recognize him. How did he get in? I don't know, but I know I didn't give him permission. He shouldn't be here. So it's much clearer under the confines of the Cushenberry rule. And the problem with Rao is it allows people to make hasty, deadly decisions based on incomplete information.
But wouldn't there be some risk to them? I mean, the Make My Day statute has a number of elements. One, it has to be an unlawful entry. The person, the victim, needs to have been committing a crime or about to be a crime, et cetera. I mean, those would be, so the person in Mr. Rao, in Mr. Rao's place would take a significant risk. If you don't satisfy those provisions, you're going to stand on trial for murder.
Well, he does. And, I think it's important to emphasize that a person in this situation is not defenseless. It's not as if they have no ability to exercise self-defense. What they don't have, if they're not in their dwelling, is this uncommonly broad right to use deadly force in response to how a very minor application of physical force or threat of physical force. So I understand the situation that Mr. Rao was in, and I appreciate, you put yourself in his shoes going into that basement. Obviously, there was no light, and you didn't know what you'd encounter. It would be a very unnerving thing. However, he left his apartment to go down there, and it was a common area of the building. I mean, there was testimony to that, putting aside the question of whether it meets a legal definition. The testimony was that all the tenants went into that area, and they had access to that. So Mr. Rao made a choice to leave his apartment and enter that common area, and he certainly didn't forfeit his right to defend himself completely, but I do believe that he is in a position where he gives up the right in a common area to exercise the right to use deadly physical force under Make My Day.
If I can ask one question, I promise I'll leave you alone. Could you address Jimenez?
Sure. Jimenez came out 3 or 4 years before the Make My Day statute was enacted. Jimenez does not address the issue that's before the court here at all, or the issue that was in front of Cushenberry. Jimenez is a single-family dwelling, and it dealt with the garage, and the garage was attached, and like the rest of that dwelling, the garage was a place where the person who was I don't know if it was a rental or an owned home, but that person had the right to keep out everybody. And it's a little bit different here. If, for example, a parking garage were attached to an apartment building, that would be different than a garage attached to a single-family home. It's the nature of the structure and who has control and how much control they have. I think that makes Jimenez distinguishable. And the interesting thing is, Cushenberry didn't cite Jimenez at all. And I think the reason, I mean, I'm speculating, but Jimenez didn't have anything to say about the issue of the common areas and whether they were part of a dwelling.
Mr. Baker, what if the landlord of this house, instead of dividing it into 7 individual apartments, had rented out the 7 bedrooms and people use the kitchen in common? Or, think of the many students in Boulder or Fort Collins who live in group homes. Would you say that the kitchen in a group home is not subject to the Make My Day defense because it's shared by all the people living in the home? Do people living in single families get a sort of different application of the law than people who are living with those they are not related to?
Your Honor, I think if we're going to accept Cushenberry, and I realize you don't have to, I think that's the outcome because it's a shared area. It's not an area under someone's exclusive control like the single-family home in Jimenez was. And I guess the question that arises in my mind in that situation is, does the legislature have a problem with this? Because they set out the parameters under which you can use deadly lethal force under Make My Day. And it doesn't appear that they have any problem. And that, again, goes
And you
to
say
this-
that they don't have any problem because they didn't react to this one-page Court of Appeals opinion? I mean, that's the basis on which you're arguing they don't have any problem?
Well, I think that statutory history, that's part of it. And if they did have a problem, they've waited 30 years and haven't addressed it. And obviously, I think the takeaway from the history of this statute is that when the legislature, first of all, they're aware of how the courts are interpreting this statute. We know that because in 2016, they moved swiftly to correct an interpretation of the dwelling definition with which they disagreed. But it hasn't moved to abrogate Rao. And unfortunately, we don't have a legislative oracle who can come in and tell us what they're thinking. But there's an implication there that Rao, nearly 30 years out,
Cushenberry?
or I'm sorry,
No
yes,
worry.
Cushenberry. I was afraid I'd make that mistake. Cushenberry is satisfied, or the legislature is satisfied with that interpretation. So I think, it's difficult, but it's a situation where there has to perhaps be a bright line drawn, and the legislature has drawn it, and they're saying that common areas are excluded from a dwelling.
So we've spent a lot of time talking about the case law and almost treating Cushenberry as if it's the statute. Talk to us about the statutory language, particularly the statutory definition of dwelling and then building. And I know you may disagree about whether that truly controls in this setting, but let's assume for the moment that it does. And help me understand how it would not comprehend the entire building.
Well, if you look at the definition in a vacuum, it does apply to the entire building, no question. Dwelling means a building that's used or intended to be used for habitation. However, it appears from the legislature's actions that they've carved an exception out of that in the context of the common areas of an apartment building.
And that's again based on the negative inference arising from in the wake of Cushenberry.
Yes. And
It always seemed a little tricky. We sometimes go down that path, but it's always seemed fraught to me because it is a negative inference and we don't know what they're thinking. I mean, it could be the press of other business, could be any number of things. You're right that in some instances we see swift action that's taken in a similar area, but it does seem like it's I don't know, hazardous for us to surmise too much from the absence of action.
Well, I all I can say is when I was researching this, I saw cases from the court, and one of the cases I cited in my brief was under the doctrine of stare decisis, and I ran into a couple cases. In one, they were looking at the court was looking at a Court of Appeals case that was several years old, and the question was, should we overrule this? And the argument in favor of not overruling was stare decisis, and the opinion, and I don't remember the name of it, I'm sorry. They said, no, 2 years is not long enough. There is another opinion, which I cite in my brief, and quote, there's a block quote in there, where the Court of Appeals case had been in effect for 20 years without being overruled. And in that case, this court said, we really don't think that given the amount of time that that's been in effect, that it makes sense to overrule it, not only because maybe the legislature hasn't acted and we don't know, I suppose they could be asleep at the switch, but just because we need certainty and clarity in the law. And that takes me back again to Cushenberry versus Rao and the problem with Rao, which is how do you tell, how does a person who is looking at using deadly physical force, maybe they have seconds to decide, if they're in a common area and they see somebody and they're up to something suspicious, how do they make that call? You know, if they go by a janitor's closet and they see somebody they don't know hauling out tools and cleaning supplies, they could be committing a theft. What do they do with that? If they're in their own apartment or dwelling, they obviously know whether that person should be there or not. But when you get into the common area of an apartment building, things get really fuzzy. And if you're going to have this kind of law, which we have, which almost gives somebody the right to a hair trigger to use physical force, it should be very clear the circumstances under which that should happen. And I don't think that Rao supplies that. If there are no more questions, I'll reserve the rest of my time, but I'm happy to take them if you have them.
Seeing none, thank you very much. May reserve the 8 minutes, 49 seconds. If you'll take your cover, Mr. Baker. Mr. Baker, if you'll take your cover. That's all right, everybody does it.
Failing microphone 101.
May it please the court. The issue being addressed concerning this case is whether or not the Court of Appeals erred, and further, whether or not holding that the basement in question was a dwelling for purposes of the Make My Day statute. The people's argument, and the cornerstone of their argument, is the case of Cushenberry. And I'd like to discuss Cushenberry and discuss what it says and what it doesn't say. Statutory definition of dwelling never mentions common areas of an apartment building. The language solely comes from Cushenberry. Cushenberry was decided in 1992, and as I read it, it consists of a mere 5 paragraphs. The sole basis for appeal in Cushenberry was that the trial court in that case failed to instruct the jury on an affirmative defense under 18-1704.5. The court in Cushenberry stated that there must be evidence in the record to support an instruction embodying a defendant's theory of the case. And the court went on to say for the defendant to be entitled to an instruction on the affirmative defense as defined in 18-1704, he was required to present some credible evidence that he met the 4 elements defined in 18-1704.5. The court noted that the trial court concluded that the evidence did not support giving an instruction on what's been described as the Make My Day defense. The court then gave us the following recitation of the facts. The defendant was sitting on a windowsill landing in his apartment building when the victim confronted him demanding money. An altercation ensued, during which the defendant shot the decedent. Those are the facts. We do not know what other evidence was presented in trial to support the Make My Day instruction. We do not know what the evidence was or how many elements fell short in establishing the instruction so that it would not be given. We do know that the Cushenberry Court, like Rao, Jimenez, Alanis, Morales, applied a definition of dwelling. And dwelling is defined, and it's been stated in the briefs many times and said here today, is intended to be used or is usually used for habitation and as a building. That's the statutory definition of the black letter law. Cushenberry went on to say that the stairwell was not part of the defendant's apartment, but was a common area used by other tenants and their guests. The stairwell, presumably, in this case, was near the windowsill. I found it interesting that we were talking about a windowsill, that there's two people that know each other, that there's an altercation, and then there was a stairwell. So the Cushenberry Court applied, presumably, the definition of a dwelling because it was cited, but there appeared to be no application as to why this wasn't a dwelling and where it failed, and if it failed on other elements of the Make My Day affirmative defense instruction. The Cushenberry Court could have merely concluded that the circumstances in that particular case did not meet the statutory definition. But they went on to state this common areas portion of it, that the stairwell was not part of the defendant's apartment, but was a common area used by tenants. That's a broad statement. It was not necessary for the decision. The decision could have been simply failed to meet it, and here's why it did not fall into the definition of that. But instead, with a broad stroke stated, common areas are excluded, and according to the DA, or the people in this particular case, this broad stroke from 1992 overrides black letter law from the legislature. It's our position that it was unnecessary in the court's decision and that it was dictum. The Supreme Court itself has defined dictum as judicial comment that is unnecessary to the decision in the case and therefore not precedential. Sullivan v. People. Also citing Maine Electric, this statement is conclusory and made without analyzing the contract terms and appears in dictum. And then later in Maine Electric, they said dictum is not controlling precedent. And that's really what we have
Mr.
right
Bussey.
here. Yes,
Mr. Bussey, right here, sorry.
Sorry.
Good afternoon to you.
good afternoon.
How are you?
I'm doing well, good to see you.
So where would you draw the line, or where would you have us draw the line? What rule would you have us adopt in terms of what constitutes a dwelling?
I think every trial court needs to apply the habitational definition of dwelling. I think Cushenberry is an example of where a court tries to establish a bright line to where it doesn't consider circumstances that Mr. Rao lived in concerning unique living arrangements that are becoming more and more common here in Colorado. Not every Coloradoan has a single-family dwelling. And so to answer your question, Justice, is I think that definition needs to be applied on a case-by-case basis.
So if it's used for habitation and the basement was uninhabitable, how does that help you?
Justice, the people have stipulated that it was part of his habitation, so that when we take a look at the definition of the dwelling, the people in their page 10 of their brief have said that it was used for habitation. And I want to go back, I believe it was Justice Hart, concerning the question of how the layout of this building. It's an old Victorian building. It's been carved up, as many other buildings are, as real estate becomes more difficult. And the photographs and the way this is laid out is there was 3 locks that needed to go through by the intruder to get to where he got in this particular case. There was an outside door, and then there's a space that leads to the basement. And the testimony is that the tenants had access to the basement to adjust the water heaters, the thermostat, storage. There was items that were stored there. And then down where the intruder was found, there was another lock into the room where he was found that was broken open. So as far as the habitational use in this particular case,
And I guess, I'm sorry, I'm just to be clear, I'm trying to get you to flesh out the question that Justice Samore had asked in terms of crafting a rule that trial courts can apply in the future. And we use the phrase, if the touchstone here is used for habitation, what are the parameters of that? Storage of items? Is it utilities? Is it, help me
I
with that.
understand. So I think the first part is that the definition of dwelling applies. The second part of that, as far as crafting a decision for future trial courts, is really some time of use or intended use for habitation. I mean, a lot of the conflict that comes from this is there's one definition of dwelling, and then there's burglary cases where, interestingly enough, the defense is typically arguing for a smaller definition of that. And then we have Make My Day, where we're saying, well, just follow the rules on this. And the people have tried to submit and argue, well, there's different rules of dwelling for habitational use on Make My Day versus burglary. For example, in Morales, which is a Court of Appeals case, the factual scenario was unique because it was a house that was being constructed. And the court in that case ultimately really relied on the intended for habitation. And in this particular case, the habitation for Mr. Rao and others is that it had exclusive use. The tenants were the only ones that could get down into this area. It was not a windowsill where anybody could just be there. Second, it was locked. You would have to have a key to get down there. The room where the intruder was found had an additional lock that was on there that was broken off. So for purposes of crafting this, and I believe the trial courts can generally detect and apply the law concerning whether or not an area was an open lobby, so to speak, or was an area that was closed off and used for the habitational use of the tenants.
Well, are those part of the definition that you would ask us to apply? I mean, analogous to the cases you cited about and you're in through the first level of the locked door. Is that a limiting principle here? That, it needs to be a place where only the tenants had access to it and it was locked? Are those factors relevant? That would limit the definition of dwelling for this purpose. Is that what you're suggesting?
Well, Justice, the difficulty is, and it was discussed not only in this case, but I think in the previous cases, when we get into hypotheticals, it's difficult. I think for purposes of the analysis for this court, I think it's factors need to be considered, and a locked door would certainly be an important.
Sure, but let's take, a 50-story apartment building in New York City, and the doors are open. Probably not the case anymore, but anybody could just walk in and go up to the swimming pool. That not technically open to the public, but it wasn't locked. Anyone have access there. Would that be part of the habitation for all 200 residents of that big apartment building?
Well, I think there has to be, and for this court to consider, the definition of dwelling is surely a broad stroke. But I think for this court in crafting a decision, there has to be some definition of exclusivity. And where that exists, I don't know.
So as a hypothetical, let's assume the same facts that we have here, except that there is nothing in the basement. No furnace, no thermostat, no water heater, no refrigerator. It's completely empty. Different outcome?
Perhaps. Yes, Justice, to address that issue, Judge Dubois, the trial court judge, certainly considered the fact that these tenants stored items down there. They had exclusive access to this area. For temperature control, they needed to go down there to adjust their heat. For the water temperature, they needed to have access to go down there. And I know that was considered by the trial court. If you eliminate those, is there still enough? I don't know, but I would submit that certainly that's for the trial court to weigh concerning that.
What if it's a single home or just a single family home? So you don't have apartments, it's just one family living in that house, but you've got a basement, just the same kind of basement as here, but it's completely empty, unused, no water heater, none of that.
Yes.
Then
Yeah, if I could answer that.
Please.
Single-family homes is, and it appears from the people's argument, seems to be, that's the easiest way to deal with this, is to say, let's limit this to single-family homes. And I'm not implying that that's Mr. Baker's argument, but essentially, that's been the easy one concerning burglary-type cases. But in a single-family home, there would be absolutely no doubt because there would be exclusivity there. And I don't have an operational definition of exclusivity that I could assist the court in drafting on this, but my point would be that clearly, when you have multiple people living in one place, the court is going to need to ferret out whether or not that was part of the individual occupant's habitation. And there are so many different types of living positions here in Colorado. I mean, in Little Colorado Springs, they're proposing a 25-story building at this moment. So we're going to be dealing with different types of living arrangements here in Colorado that are different than single-family homes.
So, Mr. Bussey, though, does that argue in favor of more of a bright line rule, though, instead of what you're advocating in terms of case by case? I think about sort of how the world has changed over the past 10 years in terms of Airbnb and VRBO, and I think about mountain resorts with common areas. And I mean, how, do condominium renters who turn around and rent out their apartments over one of those platforms need some certainty understanding kind of where those lines are, as opposed to thinking, well, I have 3 seconds to make this decision, and I don't know. Is this a common area? Is this yeah.
I think my position would be is that as the court did in Rao, they went through the particular living arrangement concerning Mr. Rao in the particular building, and the court applied that to what we would agree is a broad stroke, but the courts need a broad stroke given the different types of living arrangements that exists. And to get back to the point I made earlier, is exclusivity is one of the factors that the court looked at concerning that area. So to answer the court's question, there's not a simple bright line that I can think of concerning this, and I would ask that the legislature be respected on how they've drafted this.
Mr. Bussey, how do you respond to the argument about the lack of familiarity with people? And, we're talking about being authorized or allowed to immunized to kill someone. And there's that familiarity question.
Understood. Chief Justice, the people have, I think the position of the people is really based upon, we're going to get into people that are just shooting people in apartments. I think it's kind of a fear-based, this is going to encourage those that don't know any better just to shoot and say, well, because of the Make My Day law and we're in an apartment complex, it's open season, I'm just defending my place. I disagree with that because a person operates, as always, at their own peril when they assert an affirmative defense such as self-defense, and also the Make My Day statute. And the people are making the argument, hey, they didn't do any identification. I would point out in this particular case, Mr. Rao observed the damage to the lock. That door was not supposed to be open. Went down into the dark basement, was wearing a headlamp, and didn't go down there in 3 seconds and just shoot somebody. He was down there for minutes, and the intruder became more and more violent. So to answer the question, Chief Justice, the concern of the people that people are going to be shooting people, everyone is always at their peril when they make an act like that, especially involving deadly force. And I think the other criteria is still going to apply. So even though it is a fear-based argument, I don't think it's going to create the mass shootings that the people.
Let me follow up. You said the phrase that there needs to be some definition of exclusivity. What would, tell me what your definition of that would be? How do we weigh that?
Well, to get back, and if I could answer this, Chief Justice, the exclusivity would be a factor for the courts to consider in addition to other factors of, whether it's the person is It's a part of habitation. I think getting to the definition, Chief Justice, it would have to include, locked doors, the typical working operation of the particular habitat that is being analyzed by the court. So whether or not people can just go in there at any time, whatever that space may be, the example came up of a common kitchen. I would tend to believe that a common kitchen at CU Boulder, there would be some level of exclusivity for the users to go into that kitchen. Does that answer your question?
Answers the question by saying it's a tough question, I think. Yeah.
As today, I've heard a lot of answers that have been answers to tough questions.
It's sort of, I'm sorry. It sort of feels like you're inviting us to trade one form of judicial gloss for another. And so I guess I find myself wondering, especially in light of Mr. Baker's answer earlier to my question about just the plain statutory language. I heard him to say that if the legislature hasn't tacitly embraced Cushenberry, you win. And so I guess I'm surprised that you're not clinging more to the plain language of the statute, rather than encouraging us to come up with another formulation of this.
Justice, the plain language of the statute is the law, and that's ultimately my point, as I've made in the briefs. The question earlier came up concerning factors and how I would consider exclusivity, and I'm merely stating to this court that the black letter of the law works right now, and the issue has to be as to what a court can consider, and I think Judge DuBois' decision was a good one concerning what she considered Mr. Rao's dwelling. So all I'm asking the court to do is to follow the current legislative law in black letter as it's written concerning the definition of dwelling and its application to make my day.
And if that strikes the legislature as being too broad in this context, presumably they can tell us so.
Well, when I said it uses broad strokes, it needs broad strokes because there can be many different scenarios, and we have to trust our trial courts to apply the definition and to differentiate between whether or not somebody just walked in and somebody walks into a certain particular place and deadly force is used versus applying a factual basis, which was done here in the Rao case. I mean, the court heard 2 days' worth of testimony concerning the living arrangements of Mr. Rao, far more in depth than anything that the court, at least appeared to have considered in the Cushenberry case. So I'm trying to address the court's concerns concerning drafting a decision on this to give trial courts guidance, and I'm merely suggesting that the courts should take a strong look at what Judge DuBois did here and take a look at all of the particular elements.
Mr. Bussey, while you've paused, I'm going to ask you what might be an unfair question, but I'm going to ask it anyway. A little bit of an elephant in the room. Could you address more of the facts of what happened here? I have to say, when you read the facts in the people's brief, there's a little bit of a gut punch at you. And so you've alluded to the fact that the victim here became violent. I guess I'd like to hear more of that. I mean, you read in the statute, I recognize we're here to discuss the meaning of dwelling. There are a number of facts that you have to look at. It's an unlawful entry, that the victim was committing a crime or believed to, that there was a threat. I'm paraphrasing. Could you help me understand how all those facts kind of fit here?
I can. Justice, to describe 219 North Wasatch, it's in a rough area. It's an old Victorian home where there's an absentee landlord, and it's not a place you would want to live, nor your children or any of your family members. It's a difficult area. There's a lot of homeless there. When you pull up to the area, there's a lot of no trespassing signs, and you can see where the lock has been chiseled away before and in fact repaired. And in this particular case, there's a door to get into the back, essentially, that's related to the parking lot. And there's been rampant drug use in that area. Mr. Rao, in talking to the detective, and he was very open and forward concerning what happened, has said that I found drugs, throughout the area. I found syringes. Days before, he had been threatened with his life while he was outside. The place has been broken into previously. that when the police are called, nobody comes. This is the area where he lives. And as I said earlier, it's not a place, and any of us would really want to live, but it's a dilapidated house. And it's the best that a person can do living in downtown Colorado Springs because the rent is cheap. And at this time, his girlfriend came up and said, I believe that there's an intruder there because the doorway to the basement was open, and he went down there with a headlamp and armed with a gun, which he slept with at his side to defend himself. And when he went down there, he nudged the intruder with his foot, who was on the floor, woke him up. The intruder then became violent, as described by Mr. Rao. I would note
Did he
that
stand up? The intruder, or did the intruder stand up?
Mr. Rao said he couldn't remember. It was on his knees, and then he said, I can't remember if he stood up. The intruder in this particular case was 6'5", and he began throwing things, to include a doorknob that was found. And Mr. Rao was standing there with his headlamp, and this was all heard by Mr. O'Connell, who lived above. And Mr. O'Connell said that he could smell the drugs coming up from the floor and couldn't figure out where it was coming from previous to this happening. So to shed light for the justice, there wasn't a lot of time concerning this, and the intruder was in a small room that had a lock that was broken off when he went down there. And he was found with drugs in his hand. He was found with a knife at his side. He was found with burglary tools. This was not, as the people would have you believe, somebody that was just a stranger in the area. He asked him to leave, and the person refused to leave, and he shot him. That's not the facts here.
Well, I'm just curious, what was the crime that the district court found the victim was intending to commit or had committed?
Yes, we went through a list of potential crimes that included trespass, drug use, menacing, assault. There was many crimes that were addressed concerning that.
Yeah, of course, our job is not to evaluate the equities. It's just to figure out what the statutory language means. And it seems to me a lot of these policy choices that we are talking about would be better left to the legislature. It seems to me Cushenberry ultimately represents a judicial policy choice that perhaps we disagree with, and we do better just to punt it back to the legislature and let them more expressly tell us how they want to handle this.
The legislature has drafted the Make My Day law. And in 2016, as Mr. Baker has pointed out, there was the additional paragraph was added concerning jail cells. But in that statutory history, there was nothing concerning to do with any apartments. And my point would be is, as I've stated before, that was dictum. Second of all, this Cushenberry case was a 1.5-page decision. And I actually ran the Westlaw search concerning this, and I was just curious because I can't remember which Chief Justice or which Justice asked that, but it really hasn't been cited.
At all?
There's Alanis, where there was a mention of that, and then I see Rao, and then there's a Kansas case called State v. Spangler, which is all I could find when I did my little Westlaw search. So I find it interesting that people are saying that there's some kind of tacit affirmation by the legislature. I don't believe that to be true.
What are other states doing with this issue, of anything?
Well, when I was taking a look at this, I was really focused on the issue of dwelling concerning this, because the way I saw this is we're looking really to see if this is somebody's home and whether or not they live there, the habitat, et cetera, and applying that. So when I went to and found the Massachusetts case, I was looking to see if I could find anything to assist this court and Mr. Rao concerning the Make My Day. And the Make My Day law it's really an interesting type of legislation because it is an immunity against prosecution. It's an ancillary hearing that exists, but it's not where evidence is just suppressed. It actually creates an immunity that creates, really the Gunther court had a difficult time trying to work its way through that. So to answer your question, I don't have a lot of law concerning what other states are doing with the particular Make My Day law. I can only tell you that other courts are addressing the dwelling issue. I do believe that the black letter law is clear on this, and Justice Hood, you brought that up earlier. And when we get into the law concerning Make My Day, and I was taking a look at this and thinking about that very issue, the courts, and especially the Court of Appeals, lack authority to redefine the elements of liability or defenses to the prosecution, and the power is exclusively with the General Assembly. And, you know, we can go back to Marbury versus Madison, but to preserve separation of statutes, the court must construe the statutes to affect legislative intent. And that's what we're asking you to do on this case. And I recognize for a court such as the Supreme Court is constantly concerned about how trial courts are going to be applying this on a day-to-day basis. But I think that is a job for the Assembly. I would simply state that I think that Judge Dubois did a great job breaking this down concerning her decision. It's not simply because I won, but quite honestly, the trial courts are busy, and for her to take a couple days to hear testimony was kind of nice. The Court of Appeals interpretation of law in Cushenberry is not binding on other panels of the Court of Appeals, and I would just submit in the last couple minutes. Judge Dubois references Cushenberry in her decision. The Court of Appeals referenced Cushenberry in their decision, and they both applied the statute concerning this to find that the evidence was sufficient to meet the elements of the Make My Day statute. And quite honestly, I don't like the term Make My Day. You know, it comes from an old Clint Eastwood movie. I think that you know, when we take a look at the title that the legislature has called this, use of deadly force and against an intruder, it's really more appropriate to call it that, but I've called it Make My Day as well, just because that seems to be what it's been picked up as. Lastly, you know, I think I touched on some of this concerning some of the facts when Justice Gabriel asked me to give a little bit of context concerning this. But there was substantial evidence to support Judge Dubois' decision and for the Court of Appeals to approve that. There were no trespassing signs, and I would note just in Cushenberry, I found it interesting that one of the cases they cite when they're trying to differentiate between dwelling and what's not a dwelling, and I think it's DGP, people in the interest of DGP, they found that there was, in that case, that there was no locks, that there was no exclusivity, that anybody could seem to come and go. And I just happened to notice that when I was taking a look at some of that. Justices, I thank you for the time on behalf of Mr. Rao. I'm asking you to affirm what two courts have found in this particular case, that he did act under statute concerning this. Thank you.
Thank you, Mr. Bussey. Appreciate your argument. Mr. Baker, you've got almost 9 minutes for your rebuttal.
Thank you. 2 points I hope to make in rebuttal. I didn't address the district court judge's ruling, but it was talked about quite a bit in Mr. Bussey's presentation. I want to address it briefly. Judge Dubois obviously had to deal with Cushenberry, and unlike the Court of Appeals, she couldn't ignore it. If she wanted to not apply it, she had to distinguish it, and she did, and she applied this kind of habitation test looking at what the purpose of the basement served, and decided that because the basement had essential essential controls for habitation, the heat and water, that it was different from Cushenberry.
Mr. Baker, I'm going to interrupt you, I'm sorry. So apropos of, I think, what Justice Hood has mentioned a couple of times, and I think Justice Birkencutter also made the observation that there are all kinds of living situations, and it's impossible for us to foresee all of them. I think Justice Hart may have mentioned a couple of them as well. Why wouldn't we just apply the statute in Jimenez here and, let the legislature deal with specific types of living situations such as common areas that maybe they haven't they didn't foresee when they passed the statute. I will add that, as you may know, at one point there was a case where the statute was invoked at a detention facility. And, the legislature then subsequently came out and said, oh, wait a second, dwelling doesn't include that unless the context indicates otherwise. And so, the definition of dwelling is such that it could have been interpreted as applying to a detention facility, and the legislature reacted once it realized that that was the case. Why wouldn't we just apply the statute, the plain language of the statute and Jimenez, and say, well, this is, this falls within the definition of dwelling under the plain meaning and Jimenez?
In other words, Jimenez and Rao both, I think, reached that conclusion. Well, first response to that is maybe the legislature didn't anticipate this back in 1985, but we're a number of decades down the road, and we have a case law record, and we have some legislative response to that, and we also have legislative acquiescence to some of that case law. I think it's entirely appropriate to believe the legislature understands what is going on in the area of case law, and recognizes how it's been interpreted. To the merits of the question regarding just applying the definition of dwelling, I go back to what I said earlier about that this is almost an unheard of grant of authority to people to use a lethal amount of force. And because of that, it makes sense to put clear parameters on when it can be used. And the question is, if you're in a common area and you see somebody that you don't recognize and you're not sure who they are, what if you make this decision, assuming other things happen, like you have a belief a crime's being committed and there's going to be an application of force against you, however slight, what if you guess wrong on that? What if this person's not an intruder?
Remember, though, that there are other restrictions, right, that are not before us. I mean, Justice Gabriel talked about this, and he asked Mr. Bussey some questions about it. The only restriction before us is the dwelling restriction. So there are other restrictions, other parameters that the legislature put in place to try to make this work, and those are not before us.
That's there, and there's the Cushenberry interpretation of that, which came first, and I understand that you don't have to accept Cushenberry, but I think there's a lot of logic to Cushenberry. It provides clarity, frankly, that Rao does not apply. If you're dealing in a common area and you're dealing with someone you don't know, it's hard to know if that person is an intruder or not. If you meet them in your apartment, it's pretty clear real quickly, almost instantaneously. And if we're asking people to make these snap decisions about, do I use force or not, I think we want to restrict it. The other thing is, I just want to leave the court with this thought. People who don't have access to the opportunity to use the force that Make My Day provides, that level of force, are not defenseless. If they're not in their home or their dwelling, they are not in a situation where they can't respond to an application of force. They just cannot use the Make My Day statute. And when you look at the possibility for chaos, when you're in a common area and you just don't know who this person is, and you don't know whether they're an intruder or not, I think that Cushenberry makes a lot of sense. It provides a clarity that, frankly, Judge Dubois' ruling did not, and the Court of Appeals in Rao did not. And for that reason, we would ask that you affirm Cushenberry, that you reverse Rao and that this case be sent back to district court for further proceedings on the charge and that it be reinstated. And if there are any other questions, I'd be happy to answer them.
Seeing none, thank you, Mr. Baker. Thank you to both counsel. Appreciate the argument. Case will stand submitted and the court will be in recess.